Freedom of movement. Articles 19(1)(d) and 19(5). Article 19(1)(d) guarantees to all citizens of India the right to move freely throughout the territory of India. This right is, however, subject to reasonable restrictions mentioned in Clause 5 of Article 19, that is, in the interest of general public or for the protection of the interest of any scheduled tribe. Article 19(1)(d) of the Constitution guarantees to its citizens a right to go wherever they like in Indian territory without any kind of restriction whatsoever. They can move not merely from one state to another, but also from one place to another within the same state. This freedom cannot be curtailed by any law except within the limits prescribed under Article 19(5). What the Constitution lays stress upon is that the entire territory is one unit so far the citizens are concerned. Thus the object was to make Indian citizens national-minded and not to be petty and parochial. Grounds of restrictions. The state may under Clause 5 of Article 19 impose reasonable restrictions on the freedom of movement on two grounds. 1. In the interests of general public. 2. For the protection of the interest of scheduled tribes. In N.B. Khare vs. State of Delhi, AIR 1950, the petitioner was served with an order of externment by the District Magistrate, Delhi, to remove himself immediately from Delhi district and not to return there for a period of 3 months. The order was made under the East Punjab Safety Act, 1949. The petitioner contended that the order imposed unreasonable restrictions on his right to move freely because a. The externment order depended on the subjective satisfaction of the executive, and b. The Act did not fix any maximum time beyond which the order could continue. The Supreme Court held that the mere fact that the power to make the order of externment was given to the state government or district magistrate whose satisfaction was final did not make the restriction unreasonable because the desirability of passing such an individual order in emergency had to be left to an officer. The second contention was rejected on the ground that the Act was of limited duration, therefore, there was no possibility of an order of externment being made for definite period. But a law providing for externment of dangerous character from a particular locality cannot be called reasonable if it does not specially define as to what is meant by dangerous character, as it gives the administrative authority arbitrary power to determine as to whether a citizen is of dangerous character. In State of Uttar Pradesh vs. Kaushalya, AIR 1964, the Supreme Court has held that the right of movement of prostitutes may be restricted on ground of public health and in the interest of public morals. The right of a citizen to move freely may also be restricted for the protection of the interest of scheduled tribes. The object is to protect the original tribes, which are mostly settled in Assam. These tribes have their own culture, language, customs and manners. It was considered necessary to impose restriction upon the entry of outsiders to these areas. It was feared that uncontrolled mixing of the tribes with the people of other areas might produce undesirable effect upon the tribal people. In Ajay Kanu vs. Union of India, 1988, the petitioner challenged the validity of Rule 498 of Andhra Pradesh Motor Vehicles Rules, 1964 and the notification issued thereunder by which wearing of helmets by the drivers of two-wheelers was made compulsory, on the ground that the same was violative of his fundamental rights guaranteed under Article 19(1)(d) of the Constitution. The Supreme Court held that the rule was valid as it was made for the good of the people and imposed reasonable restriction on the freedom of movement. Rule 498 ensures protection and safety to the head of the driver of two-wheeler in case of an accident. The compulsion for putting on a helmet by the driver does not restrict or curtail the freedom of movement. In Rajneesh Kapoor vs. Union of India, AIR 2007, it has been held that the requirement of wearing helmet not a restriction on free movement of citizen. The paramount objective of wearing helmet is to save his life.